So it looks like Tiger is out of the Masters. Thank you for joining Ms Legalista, aka Attorney Sheila, here back to talk about Tiger Woods. Now, I don't really follow a whole lot of golf. I know that he had an injury and he looked like he was in a lot of pain when they were showing him out on the greens there. He was walking very slowly, and it just looked like it was a struggle for him. So I wish him the best. But let's talk about this ongoing case with Erica Herman, his former live in girlfriend, partner, I don't know, whatever you want to call it. But she is suing his trust because he broke off the engagement and sort of kicked her out of his house where he had invited her to stay as a guest when they were partners. Yeah, we're going to break that all down because I have a lot of concerns about this particular one. I really do.
Yeah.
Thank you for joining. As I said, if you've been following this, I would think that some of this stays in the back of your mind. If you're a Tiger and you're out there and you're trying to play golf, you've also got this lawsuit going on. Now, granted, she sued the trust because the trust technically has ownership of the property, but he is the one who ended the relationship. And she signed a non disclosure agreement. But she is saying that this is not valid because of a certain law that says, hey, this non disclosure arbitration agreement, the arbitration part in the non disclosure agreement, doesn't apply when there's sexual harassment or something like this going on. So she's sort of thrown this in here, implying that something has happened. Let me go to the document because I want us to really take a look at the document to see now what the trust is saying back to her. Tiger has already inserted himself into this lawsuit. I did another video on that one that you can take a look at. Let's go to Martin County, Florida, where all of this is taking place. And again, like I said before, this is Erica Herman who is suing the trust, suing the trust. But it really comes down to this agreement that she signed with Tiger. And then what happens now that he has sort of kicked her out? There's just a whole lot going on here. Motion for determination that claims are not subject to U.S. Code 9, Section 402, and for order compelling arbitration. Christopher Hubman, a trustee of the defendant Jupiter Island Irrevocable Homestead, the trust, moves this court for determination that one, the pending claims are not subject to 9 USC sections 401 through 402 because they do not constitute a sexual assault dispute or a sexual harassment dispute. And two, the claims are subject to the parties' arbitration agreement. Okay, so two things that they're saying here: that there's nothing that constitutes a sexual assault dispute or harassment dispute, and that therefore she's got to stick with the arbitration. All right, introduction. Let's get some background on this. How did we get here? What is this trust? If you guys have been following me, you know that the trust is who she initially sued for this. Let's jump into the introduction. In response to defendant's motion to compel arbitration of plaintiff landlord-tenant claims in this action, plaintiff Erica Herman asserts that this court has exclusive jurisdiction, which states, among other things, that a party to an arbitration agreement cannot be compelled to arbitrate a sexual assault dispute or a sexual harassment dispute. Ms. Herman alleges once the plaintiff invoked this statute, it requires the court to determine whether plaintiff's claim is arbitrable. Yet, Ms. Herman does nothing more than cite this U.S. code and its salacious title. The title is The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. She has never asserted any claims for sexual assault or sexual harassment and does not do so in this landlord tenant action. And if she is truthful, can never do so. Ms. Herman's bare reference to the statute without any allegations to support its application to the facts of this case is insufficient to relieve Ms. Herman of her contractual obligation to arbitrate. Rather, it is a transparent abuse of the judicial process that undermines the purpose of the federal statute and those whom the statute seeks to protect. Accordingly, defendant requests that this court, one, review the allegations in Ms. Herman's self-titled complaint for violation of Florida Residential Landlord Tenant Act. Two, determine that this action is not a case which is filed under federal, tribal, or state law and relates to a sexual assault dispute or a sexual harassment dispute. And three, order the parties to arbitrate the claims asserted in this action. So that should give you some of the background here. And my concerns too, I am sort of with the defendant here. She's sort of put this out here and says, hey, we can't arbitrate because there's a statute here that says if there's a sexual harassment dispute, then you can't force me to arbitration. But she hasn't said that there's ever been any sexual harassment dispute. She's never mentioned that. She's just saying this. I'm at a loss. And I think the part that hits me the most is the part where the defense says it undermines the purpose of the federal statute and those whom the statute seeks to protect. There are legitimate times when this statute needs to be used by people who are in a situation where they're being forced to arbitrate something, and part of the underlying issue is a sexual assault dispute or a sexual harassment dispute. And she hasn't said any of this here. So, it is a little concerning that she would bring this up in this sort of backdoor way. Really, I feel like she's coming in the back door. I'm going to sneak this in, but not really tell you that there was a sexual harassment, assault, or sexual harassment dispute. I'm just going to kind of throw this statute in there. It's a little concerning to have that presented that way. But let's go on. And, this is the defendant, but I'm having to agree with them. I haven't heard anything. I've been looking at the documents. I haven't heard anything yet. Maybe I missed something, but I don't think so. Let's go to the background so that you understand how we got here. The named defendant in this action is a trust owning a remainder interest in a Jupiter Island residence, the residence occupied by Tiger Woods. Mr. Woods and Ms. Herman commenced a romantic relationship roughly 6 years ago, though they never married. Shortly after commencing the relationship, Mr. Woods and Ms. Herman entered a non-disclosure and acknowledgement agreement. The agreement dated August 9th, 2017. Now, I did have someone mention in one of my previous comments that she had worked for him, and yes, that's correct. But what this is stating here is that the NDA was signed after they had entered into the relationship. This piece about when she started working for him and when she stopped working for him, I've never really seen that clearly laid out in the documents, a clear timeline for all of these pieces together. When did she first start working for him? When did she stop working for him? When did they start the romantic relationship? When exactly did it stop? When did she sign the non-disclosure agreement? Like all of these things put in one timeline so that we could follow along to see if there was anything untoward that was going on Tiger's side. I think that would be helpful. In the agreement, Ms. Herman agreed that the exclusive manner of resolution of any and all disputes, claims, or controversies arising between Ms. Herman and Mr. Woods of any nature whatsoever shall be resolved by mandatory, binding, confidential arbitration to the greatest extent permitted by law. Now, here's a point where I think, she could say this, that because this NDA had this language, this arbitration language in here that was so broad, and it was broad as to possibly cover sexual harassment and assault disputes, that therefore it's void just because it covered it. My understanding is this was signed before that law went into effect. So it could be that that's what she's trying to say, but that's not quite what she alleged in the document. It wasn't stated that way. I didn't see it stated that way. So it still sounds like this is sort of an after the fact kind of thing. They signed this NDA, and then later this law came into effect. All right, let's scroll down. And as I told you before, Mr. Woods owns a life interest, and the trust owns the remainder interest. And there's a special warranty deed. Okay, during their relationship, Mr. Woods, let's click back over so you can actually see everything. During their relationship, Mr. Woods invited Ms. Herman to live with him in the residence as his guest. On October 13, 2022, however, Mr. Woods notified Mrs. Herman that he was ending their relationship and that Mrs. Herman was no longer welcome in the residence. Though Mr. Woods provided Ms. Herman with temporary lodging and financial support after the breakup, Ms. Herman filed this action against the trust. In her complaint, Ms. Herman claims that as consideration for her performing valuable services for Ms. Woods that were extensive and of an extraordinary nature, she negotiated an oral tenancy agreement relating to the residence with an agent of the defendant. And really, this agent, she's saying she negotiated this with Tiger. That's what she's saying. According to Ms. Herman's complaint, for the past 6 years, Ms. Herman performed services and lived in the residence pursuant to an oral tenancy agreement, which allegedly had approximately 5 years remaining at the time Mr. Woods broke off their relationship. So you see what she's saying there, okay? I'm going to come back to that part in just a minute. Ms. Herman seeks injunctive and monetary relief from the trust, including damages in excess of $30 million, arising from Mr. Woods' refusal to permit Ms. Herman to continue to occupy the residence, and removal of Ms. Herman's personal belongings from the residence, and the alleged misappropriation of $40,000 in cash purportedly belonging to Ms. Herman. So let me stop here for a second, because I don't want to assume that you saw my previous video on this. So I want to make this clear. What she is alleging here is that at the time that they broke up, she still had 6 years left of this oral tenancy where she gets to stay in his house. Now, imagine that for a second, just from a practical standpoint, because I don't think people think about this. When people love each other and they're happy together, they're ready to move in together, and one person has a place and invites the other person to move in, they really aren't thinking about how this is going to end. I think that most people assume that if I have a house, I own my house, and I invite my significant other to move in with me, that in the event there's a breakup, I'm going to continue to stay in my house, and this significant other is going to be the one to leave. It's interesting to me that someone would even want to continue to stay in someone else's house, number one. Number two, where they're not wanted to be in the presence of that person anymore, like that in the relationship that they had. It would just be awkward. And then when there are other family members involved, children, it just sets something up that's awkward. She's then, on top of that, asking for $30 million, the value that she says would have been for the remaining 6 years that she had negotiated in this, quote, oral tenancy that she is speaking of. One thing to note is that most states require tenancies for longer than a year to be in writing. Typically, an oral tenancy of this length would probably be void under statute of frauds law in most states, and I believe Florida might have that also. But let me go back to it. So I want to make sure that you understand that. She's saying that there were 6 years left, therefore she should get 30 million because he kicked her out. There was $40,000 that's somehow gone. And yeah, she's saying, no, this is wrong. And she filed this complaint against him. All right, let's go back to the document. On December 20th, 2022, defendant moved to compel arbitration. So the trust wants to arbitrate these claims, citing the arbitration provision in the agreement, the NDA. And noting Mr. Wood's involvement in the claims, defendant's motion argued that Ms. Herman had agreed to arbitrate all disputes with Mr. Woods in a confidential proceeding before the American Arbitration Association. In response, Ms. Herman argues that she cannot be required to arbitrate her claims because a new federal statute, 9 U.S.C. Section 402, provides that a party to an arbitration agreement cannot be required to arbitrate a sexual assault dispute or a sexual harassment dispute. So that's why she's saying there can't be an arbitration, because this new law, this new statute says you can't arbitrate these kinds of disputes. But now remember, that's not what the dispute is. I just told you it's about staying in the house. Does that make any sense? Help me here, because I'm sort of out here on my own here. The trust then states, Ms. Herman's position is utterly meritless. Nevertheless, 9 U.S.C. Section 402B makes it clear that whether the federal statute applies and thus bars an arbitration shall be determined by a court rather than an arbitrator. Accordingly, defendant asked this court for an order determining that it does not apply to the claims in this case. Okay. So once this claim is sort of out there, once she's used this and brought it up to say, hey, we can't arbitrate because that's what this law says. You can't arbitrate a sexual harassment or sexual assault dispute. You have to then have a court determine whether or not that even applies. So the defendant says, hey, court, can you tell us whether or not this applies? So now defendant says, here's why it doesn't apply. Okay. And they've got the statute right here. I was going to bring it up on another page for you, but look, I love it when we have a really good job here with the document and it's right in here. Most people do this, guys. This is not anything special here, right? Federal statute does not apply. It says, notwithstanding any other provision of this title, at the election of the person alleging conduct constituting a sexual harassment dispute or sexual assault dispute, no pre-dispute arbitration agreement shall be enforceable. And I'm just going to leave it at that. Shall be enforceable. No pre-dispute arbitration agreement shall be enforceable. And that's what she's saying. Under the statute, a pre-dispute arbitration agreement is any agreement to arbitrate a dispute that had not yet risen at the time of the making of this agreement. A sexual harassment dispute means a dispute relating to conduct that is alleged to constitute sexual harassment under applicable federal, tribal, or state law. Okay, she hasn't alleged sexual harassment. Did I miss that part? Because I don't see where she has alleged that yet. The term sexual assault dispute means a dispute involving a non-consensual sexual act or sexual conduct, including when the victim lacks capacity to consent. I haven't heard her allege that. Remember, we just went through what she was asking for. The 30 million, it's all related to him not allowing her to continue to stay in the property. Tellingly, when completing the civil cover sheet for this action, plaintiff's counsel checked the box for no when asked, does this case involve allegations of sexual abuse? Let me stop right there, because that almost feels like part of a smoking gun. It really does to me. Here you had the cover sheet for your complaint, and it's asking you about a sexual assault. And you say, no, but you still want to sort of say there was something like that in order to not have to do arbitration. You guys help me if I am missing something here, because I just don't see that she's alleging sexual assault anywhere. She just talks about not being able to stay in the house and that they took her $40,000 and did something with it. Consistent with this acknowledgement, Ms. Herman's self-titled complaint for violation of Florida Residential Landlord Tenant Act does not contain any allegation remotely suggesting sexual harassment or sexual assault, nor does it contain any reference to a federal, tribal, or state law relating to sexual harassment or sexual assault. Rather, Ms. Herman's complaint alleges that the trust breached a purported oral tenancy agreement and seeks damages in excess of $30 million under Florida's Residential Landlord Tenant Act. You guys, I read this. I'm with the defendant here. There was nothing in there about a sexual assault or sexual harassment. It just wasn't there. By enacting 9 U.S.C. Section 402, Congress intended to prevent those accused of sexual harassment or sexual assault from relying on arbitration agreements to force sexual harassment and sexual assault disputes into confidential proceedings outside the public eye. But the statute is not implicated merely because a party to an arbitration agreement makes reference to it in a court filing. They're saying you got to have more than that. Rather, the statute is implicated only if the underlying claims relate to either a dispute relating to conduct that is alleged to constitute sexual harassment under applicable federal, tribal, or state law, or to a dispute involving a non-consensual sexual act. And she hasn't mentioned either of those. It says here, Ms. Herman's claims relate to a lease dispute under Florida's Landlord Tenant Act, not a sexual harassment or sexual assault dispute under federal, tribal, or state law. No reasonable reading of Ms. Herman's complaint implicates 9 U.S.C. Section 402. You guys, I read it. You'd have to pull some stuff out of thin air because there was just nothing there. Go back and look at that video. Ms. Herman is not a victim of sexual assault or abuse sought to be protected by Congress when enacting the statute. Rather, Ms. Herman is a jilted ex-girlfriend who wants to publicly litigate specious claims in court rather than honor her commitment to arbitrate disputes in a confidential arbitration proceeding. Okay, so that was when they decided to hit hard, when they called her a jilted ex-girlfriend. That sounds rather hurtful. Let me stop here for a moment. There is the possibility that something could have happened and that she has never alleged it. Sometimes it's very hard for people who've been through traumatic experiences to talk about it, even in this context, to be able to say, okay, I'm going to put the details down in the complaint that actually substantiate what I need in order to be able to make this claim that there was sexual assault or sexual harassment and there's a dispute about it. Maybe I'm, still trying to process what happened to me. I'm still trying to get over that. And so maybe that's why it's not in there. But it's been going on for a while now. She's had time to put this in there. And it doesn't so much fall on her as it falls on her attorney to make sure that this is backed up by something. And yet there is nothing. There is nothing in these documents alleging that there was some sort of sexual harassment or sexual assault that was done on Tiger's part. And so she's throwing this in here. Like I said, it's concerning to have it put in here when it's not substantiated, when there's no reference to it whatsoever. So that's concerning. I want to give her the benefit of the doubt, but it's really hard. It's hard to do it here without anything when you're not really putting anything in the document. It's hard. We are getting to the end here. Wherefore, defendant respectfully requests that this court, 1, determine that the pending claims are not subject to 9 USC sections 401 through 402 because they do not constitute a sexual assault dispute or sexual harassment dispute. 2, determine that the claims are subject to parties' arbitration agreement. And 3, enter an order compelling Ms. Herman to arbitrate her claims in this action. And then there you have all of the final wrap up pieces of this. Now, I'm going to go back and pull up the docket on this just to make sure that I haven't missed any documents on this where she has come back and added information. But let me just check one thing before I say that, because this particular document was, this is certified March 13th, 2023. Yeah, March 13th, 2023. We're now not quite a month later, so maybe there's something else that's been filed, but I've been following this and I haven't really seen anything that she's claiming around sexual assault or sexual harassment. I think she loses on this. I really do. Unless the attorneys are going to show up in some sort of hearing and bring some additional information, I don't see it. I just do not see it. I think she loses on this one. I don't think you can reference a statute without telling why it would apply to your case. I'm just going to say that this applies, but I'm going to give you no background information in my case about why it applies. So this is harmful. I have concerns about it. It's harmful not just for her case, but it's harmful in general to people who have legitimate claims. And like I said, I think she loses on this. Let me know in the comments if this makes any sense to you, why she is doing this, and whether or not you think she is going to lose this round. All right, go ahead and give the video a thumbs up if this helps you with a little bit more understanding around what's going on here. And don't forget to subscribe. Peace.